Good afternoon. Thank you for joining Mayor Brown's Global Financial Markets teleconference series. Today's call is entitled The CFPB, Consumer Protection in the Age of Coronavirus. My name is Ori Lev, and I'm a partner in Mayor Brown's Washington, D.C. office and a member of the Consumer Financial Services Group. My practice focuses primarily on representing financial institutions and other companies in government enforcement matters and internal investigations, and providing regulatory advice and counsel on federal consumer financial and economic sanctions law. First, a couple of housekeeping items. As regular listeners will know, this call is being recorded. We will be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will also be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayorbrown.com, and we will respond promptly. This is the same email address as on your invitation email. Joining me today is my colleague Stephanie Robinson. Stephanie is also a partner in Mayor Brown's Washington, D.C. office and a member of the Consumer Financial Services Group. Her practice focuses primarily on representing financial institutions and other companies in government enforcement matters and providing regulatory advice and counsel on consumer financial law. With those brief introductions, we will now begin today's discussion, and I'll turn it over to Stephanie.
Thanks, Ori. So some of you know that Ori and I have been airing these CFPB updates on a quarterly basis for the last few years. And we had been all set to air our last update in March when the coronavirus descended upon America. And there were, of course, many other developments of interest that became of more immediate priority for our clients. So we got a little sidetracked covering those other COVID-19 related topics. But today we want to get back on track and cover the CFPB developments that have occurred since we did our 2019 year in review call back in December. And I'll start today by going over some pandemic-related updates before we cover some of the more routine business of the Bureau. In March, when the pandemic really started to take hold in the U.S., we saw major developments happening for the consumer finance industry, including the passage of the Federal CARES Act and other economic stimulus packages. And those were quickly followed by many announcements by various federal agencies and state governors. And of course, the CFPB has been among them. They've been vocal as well. They have on several occasions joined in with federal and state partners to encourage financial institutions to work with their customers affected by the coronavirus. For example, together with the federal bank regulators and the Conference of State Bank Supervisors, the Bureau issued an interagency statement on March 22nd that encouraged financial institutions to work prudently with borrowers who are unable to meet their contractual payment obligations because of the pandemic. And they promised in that statement not to criticize institutions for working with borrowers. And shortly after that, they issued yet another interagency statement specific to the mortgage servicing rules. And in that, they provided some regulatory flexibility that would enable mortgage servicers to work with consumers who are struggling to pay their mortgages during this time. And so on this general topic of regulatory flexibility, for its part, the CFPB has done more to announce regulatory flexibility in other areas. For example, they have postponed their quarterly reporting requirements under the Home Mortgage Disclosure Act. They've postponed some other data collection efforts that they had underway. And they have promised essentially several times that their enforcement activities would really take into account various staffing and resource challenges that they expect that are currently confronting financial institutions. The Bureau also announced a policy statement on credit reporting that offered flexibility for lenders and credit bureaus in the time they take to investigate disputes, saying that they don't intend to cite firms who exceed those disputed investigation deadlines as long as they make good faith efforts during the pandemic to do so as quickly as possible. And the Bureau also joined on to another interagency statement that addresses challenges relating to real estate appraisals. In late April, the CFPB issued a compliance bulletin concerning the handling of information and documents during mortgage servicing transfers. And in that, the Bureau said that it's continued to find weaknesses related to mortgage servicing transfers, specifically inadequacies in policies and procedures for transferring loan information and documents over to the new servicer. But they did note that during the national emergency and for 120 days thereafter, the Bureau intends to consider the challenges that entities are facing and try to be sensitive to good faith efforts to transfer servicing. Also, in early May, the Bureau issued some clarifications around the Small Business Administration's Paycheck Protection Program as it relates to complying with the Equal Credit Opportunity Act rules. And in those FAQs, the Bureau clarified that a PPP application is only a completed application once the creditor has received a loan number from the Small Business Administration or at least a response from the SBA about the availability of funds. And that is designed to ensure that the time the creditor is awaiting this information from the SBA doesn't count towards ECO's 30-day notice requirement. But the FAQs also make clear that if the creditor denies an application without ever sending it to the SBA, the creditor has to give an adverse action notice within 30 days. And they also clarify that if a creditor has enough information for a credit decision but has yet to receive a response from the SBA, then it cannot deny a loan application based on incompleteness. Another statement they issued in mid-May included frequently asked questions about the responsibility of credit card issuers and open-end non-home secured creditors during the pandemic. The statement outlines billing error responsibilities under Regulation Z, while the FAQs cover the payments and deposits rule and the open-end rules. And according to that statement, the CFPB says it will take a flexible supervisory and enforcement approach during the pandemic. Finally, in order to help expedite consumers' access to credit, the Bureau released an interpretive rule clarifying that consumers with financial emergencies can exercise their rights to modify or waive certain required waiting periods under the TILA-RESPA integrated disclosure rule. And they also issued a compliance aid on the co-evaluations rule, which the Bureau said already includes flexibility, allowing an applicant to waive certain timing requirements. So with all this talk about flexibility and sensitivity to the challenges that institutions are facing during this pandemic, I think it'll be interesting to see what kind of investigations and enforcement actions are initiated once the pandemic is over. Also pandemic-related, the Bureau has issued various resources for consumers, including a video on understanding mortgage forbearance and many, many blog posts providing consumers information on topics like stimulus relief, protecting your finances, how to submit complaints. They have launched a joint website with HUD and the Federal Housing Finance Agency that provides consolidated information to homeowners and renters on housing assistance. And they also released a consumer relief guide jointly with the CSBS that tells borrowers about their rights to forbearance and foreclosure protection under the CARES Act. The Bureau also announced a couple of information sharing initiatives. In mid-April, the CFPB and the FHFA announced a new joint initiative that enables the two agencies to share information about mortgage servicing. Under that program, the CFPB is going to make complaint information and analytics available to FHFA, and FHFA in turn will make available to the Bureau information about forbearances and modifications and other loss mitigation initiatives. And finally, not pandemic specific, but on this topic of information sharing, the Bureau also announced in February a new coordination agreement with the Department of Education. Under this new Memorandum of Understanding, the agencies will share complaint information from student loan borrowers and will meet quarterly to discuss those complaints. So that's it for pandemic-specific updates. And now I'll turn it over to you, Ori, to cover the enforcement and litigation developments of the year.
Thanks, Stephanie. The CFPB has been quite active on both the enforcement and litigation fronts in the past 6 months, with the pandemic not seeming to significantly impact their operations. Starting with litigation, the highest profile litigation event this year was undoubtedly the Supreme Court oral argument in the Selah law case, which took place on March 3rd. That's the case that challenges the constitutionality of the agency's single director structure, where the director is only removable by the president for cause. The argument covered a lot of ground: whether the court should decide the case at all, what it means for a director to be removed only for, quote, inefficiency, neglect of duty, or malfeasance in office, end quote, which is what the statute provides, whether having such a limitation violates separation of powers principles, which is the key constitutional question, and what the proper remedy should be if the current structure of the Bureau is found to be unconstitutional. Given the numerous issues and the diversity of views expressed by the justices during the oral argument, it's difficult to predict how the case will come out. But we should know within a month or so, the Supreme Court wraps up its term. The most likely outcome we still assess is a finding that the Bureau is unconstitutional, but severing the for-cause removal provision from the rest of the statute and allowing the Bureau to continue to operate. But other outcomes are also possible, including a finding that the case was improvidently granted by the Supreme Court because it's not a good vehicle for decision. I think it's safe to say that the one outcome that would be disappointing to many would be if the court decided not to decide the constitutional question, as that would extend the decade of uncertainty that both the agency and industry have lived with since the CFPB's establishment. The CFPB has also been engaged in other litigation, both defensive and offensive. On the defensive side, back in December, the agency was sued by PayPal over aspects of the prepaid account rule that the CFPB adopted in 2016. Specifically, PayPal is challenging the CFPB's application of the rule, which PayPal claims was intended to regulate reloadable prepaid cards. It's challenging the application of the rule to products that include PayPal's digital wallet, and it argues that the CFPB's interpretation is not authorized by statute and also violates the First Amendment. PayPal recently filed a motion for summary judgment in that case, and that motion and expected cross motion for summary judgment by the CFPB should be fully briefed by the end of September. The CFPB was also more recently sued by a trade association that represents credit repair organizations, and that lawsuit alleges that the CFPB's enforcement of the telemarketing sales rule, or TSR, against credit repair organizations is unlawful because the Credit Repair Organizations Act, which the CFPB does not enforce, allegedly supersedes the TSR's credit repair provisions, and it also alleges that the TSR is unconstitutional as applied to credit repair organizations. That case was just recently filed, and the CFPB has not yet responded to the complaint. On the offensive side, the CFPB has been litigating several high-profile cases, including long-pending enforcement actions against Ocwen regarding its mortgage servicing practices and against Navient over its student loan servicing practices. In the Ocwen case, the court recently ruled that the CFPB's case can proceed to trial jointly with a separate lawsuit filed by the state of Florida over Ocwen's objections. And in the Navient case, both the CFPB and Navient recently filed motions for summary judgment, so both of these long-running cases are finally nearing a resolution. The Bureau did resolve its long-running lawsuit against payday lender Think Finance and 6 of its subsidiaries in February. That settlement prohibits the defendants from collecting on any loans in the 17 states where the Bureau alleges that the loans violate state usury laws and imposes a $1 civil money penalty. And that's for the purpose of allowing the Bureau to use money in its civil money penalty fund to provide redress to consumers who are harmed by the defendant's conduct. The CFPB also filed 2 new lawsuits against banks in the last 6 months, which is an unusual development, as the Bureau almost always settles its cases against depository institutions. In January, the CFPB sued Citizens Bank over its handling of consumer claims of credit card billing errors under the Truth in Lending Act. Citizens, in turn, claims that it self-identified this issue and had already remediated impacted consumers, so there's nothing left for the Bureau to do. Then in March, the Bureau sued Fifth Third Bank over its sales practices, alleging that the bank opened unauthorized accounts without consumers' consent. And this case is the only sales practices lawsuit that the Bureau has brought since its lawsuit against Wells Fargo in 2016. Fifth Third publicly rejected the Bureau's claims, stating that the Bureau had identified fewer than 1,100 accounts out of over 10 million, or approximately 1/100th of 1% of accounts that were allegedly unauthorized and involving less than $30,000 in improper charges, which the bank claims were already refunded to consumers, and that those facts don't establish broad-based problems. The CFPB filed the lawsuit in Chicago. Fifth Third has moved to transfer the case to Ohio, and so the matter has not yet been engaged on the merits. In addition, earlier this week, the CFPB lost an important round in another long-standing litigation. Back in December 2017, shortly before former Director Richard Cordray left the Bureau, the CFPB filed a complaint along with a consent judgment against 15 student loan securitization trusts. The complaint alleged that the trusts, through their servicers, engaged in unfair and deceptive practices in connection with servicing and collection of private student loans. The consent judgment was purportedly agreed to by the trusts, but as soon as the CFPB filed the action and the accompanying motion for approval of the consent judgment, numerous trust-related parties intervened in the case to argue, among other things, that the owner-trustee had never consented to entry of the consent judgment, and that the law firm that was purporting to act for the trust was not properly retained for this purpose. After lengthy discovery and briefing, the district court ruled that, in fact, under the governing trust documents and governing Delaware law, the owner-trustee was the only party with the authority to bind the trust, and that the owner-trustee here had expressly declined to agree to the consent judgment because it believed that its terms violated the trust agreements. In addition, with respect to one of the trusts, the court found that consent from the note insurer to the trust was also required in order to bind the trust, a fact that the CFPB itself conceded. This is a rather embarrassing loss for the CFPB, which finds itself in the position of having represented to a federal court that a proposed judgment was agreed to by defendants when, in fact, the proper party had not authorized any such agreement. The CFPB has also brought us several other enforcement actions this year. In January, it sued a group of companies alleging that they improperly obtained consumer reports for purposes of marketing debt relief services, and the Bureau recently settled with some of those defendants for a judgment that requires them to pay $200,000 in redress and a total of $450,000 in civil money penalties. In February, along with South Carolina and Arkansas, the CFPB sued a company and two associated individuals for brokering contracts that purport to purchase consumers' future pension or disability payments for a lump sum payment. And that action is the latest in a series of cases that the Bureau has brought against entities and individuals on the theory that these transactions actually constitute a prohibited extension of credit. In April, the CFPB settled with a payday lender for alleged violations of the Fair Credit Reporting Act for failing to establish policies and procedures regarding the accuracy and integrity of information reported to credit bureaus, and for violations of the Truth in Lending Act for failing to provide APRs on telemarketing calls, and for engaging in unfair collection practices and deceptive advertising practices. And that settlement required the payment of about $300,000 in consumer redress and a $1.1 million civil penalty. In May, the Bureau brought two more enforcement actions. The first was a settlement with a loan servicer for violations of Regulation X by taking prohibited foreclosure actions against mortgage borrowers who are entitled to protection from foreclosure, and by failing to send or to timely send evaluation notices to mortgage borrowers who are entitled to them. That settlement required payment of $775,000 in monetary relief, waiver of $500,000 in borrower deficiencies, and payment of a $25,000 civil money penalty. And also in May, along with Massachusetts, the CFPB filed a lawsuit against a credit repair company and its owner, alleging that the company violated the TSR and engaged in deceptive acts and practices in marketing its credit repair services. And that lawsuit was filed one day after the lawsuit I mentioned earlier that was brought against the CFPB, challenging the legality of enforcement of the TSR against credit repair organizations. And then just earlier this week, the CFPB announced a settlement with a payday and auto title lender for providing deceptive finance charge disclosures and for failing to refund overpayments of loans, as well as for unfair debt collection practices. And that settlement calls for payment of $2 million in consumer redress and a $1 civil money penalty. So the agency's enforcement docket has been active, both in terms of settlements and new lawsuits, notwithstanding the pandemic. The last thing we wanted to touch on in the enforcement realm is that in March, the CFPB reissued its Responsible Conduct Bulletin. And this was a bulletin it first issued in 2013, and it sets forth what the Bureau considers to be responsible business conduct that the agency is going to consider in resolving matters. The revised bulletin essentially keeps the same 4 pillars of responsible conduct as the original bulletin, and those are self-assessment, self-reporting, remediating, and cooperating. The biggest substantive change in the revised bulletin is that now it states expressly that it is also going to apply in how the Bureau will respond to violations of federal consumer financial law in the supervisory context, whereas the original bulletin was focused solely on enforcement. Other notable changes to the bulletin include more and some different detail as to what constitutes each of those 4 pillars of responsible business conduct, including an express statement that a company's good faith assertions of privilege in an enforcement investigation will not be considered a lack of cooperation. Notably, and especially considering that the bulletin otherwise says it applies in the supervisory context, there's no similar statement about asserting privilege in the course of an examination. And with that, I'll turn it back over to Stephanie to address some regulatory developments.
Okay, thanks, Ori. There's been a hodgepodge, I would say, of relatively minor regulatory developments so far this year. Although we had been expecting to see some finality on the payday rule in April of this year, the CFPB has yet to issue its final rule. And just to refresh our listeners' recollection, back in February of 2019, the CFPB had proposed to delay the August 2019 compliance date for the payday rule's controversial mandatory underwriting provisions to November of 2020, and had simultaneously proposed in a separate notice to rescind these same mandatory underwriting provisions. So at this point, it's not clear if the mandatory underwriting provisions of the 2017 rule will in fact become effective in November of this year. We're still waiting to hear. The Bureau had proposed to rescind these, saying that the evidence underlying the identification of unfair and abusive practice in the 2017 rule wasn't sufficiently robust and reliable to support the Bureau's initial determination in light of the impact that those underwriting provisions would have. And they suggested that the approach for their unfairness and abusiveness determinations was sufficiently problematic to necessitate reconsideration. And relating to the payday rule, an internal memo from former CFPB economist Jonathan Lanning was leaked to the New York Times recently, and this memo highlighted Lanning's concerns with the payday rulemaking process, suggesting that the front office was hostile to the 2017 rule, and that an attorney advisor who had advised on the decision to eliminate the mandatory underwriting provisions had a, quote, tenuous and flawed grasp of economics, unquote. And this memo also alleges that this person, Chris Mufferidge, was responsible for senior officials misrepresenting aspects of the payday rules evidence and analyses to the press. Mr. Mufferidge reportedly had previously operated a buy here, pay here used car lot in Texas before joining the CFPB. So the release of this memo was somewhat sensational. Other rulemaking developments include a supplemental notice of proposed rulemaking on time-barred debt, a final rule raising the HMDA reporting threshold, and a final rule covering remittance transfers. In February, the Bureau proposed to prohibit debt collectors from using non-litigation means to collect on time-barred debt unless they first disclose to consumers during the initial contact and on any required validation notice that the debt is in fact time-barred. This disclosure is ostensibly intended to help consumers make informed decisions about whether to pay the debt or not. The supplemental notice of proposed rulemaking proposes some model language and forms that debt collectors could use to comply with the proposed disclosure requirements. And the Bureau has extended the comment period on the rulemaking to August 4th, 2020. The Bureau issued a final rule in April, raising the loan volume coverage thresholds for financial institutions reporting data under HMDA, which should serve to reduce the regulatory burden on smaller institutions. And in May, the Bureau issued a final remittance rule, which imposed certain disclosure requirements and other requirements on entities that send international money transfers on behalf of consumers. Among the requirements, the rule mandates that remittance transfer providers generally have to disclose the exact exchange rate, the amount of certain fees, and the amount that's expected to be delivered to the recipient. And the Bureau had also issued a policy statement in April suggesting that it would take a flexible approach to its supervision and enforcement of remittance transfers in light of the pandemic. In March, the Bureau issued a request for information to assist the Task Force on Federal Consumer Financial Law. This task force is an independent body within the Bureau whose members were announced in January of this year. And their role is to examine the existing legal and regulatory environment and make recommendations to Director Kraninger on harmonizing, modernizing, and updating the federal consumer financial laws. The last item I'll note is not really specifically regulatory, but it relates to the Bureau's no action letter or NOW process. Last year, the Bureau had issued a no action letter in response to a request by HUD on behalf of entities participating in HUD's housing counseling program. And at that time, the Bureau also issued a template that could serve as the basis for future no action letters by mortgage lenders. The Bureau's no action policy permits entities such as service providers and trade associations to secure a template from the Bureau, which can serve as the foundation for NOW applications from companies that provide consumer financial products and services. So basing its application on the template that the Bureau approved in response to HUD's request, Bank of America applied for a NOW to facilitate funding arrangements with housing counseling agencies, which the Bureau granted in January. And more recently, the CFPB issued 2 more no action letter templates. One of the templates the Bureau approved was a template requested by Brace Software that would enable mortgage servicers to use Brace's online platform to implement loss mitigation efforts for their borrowers. This platform is an online version of a Fannie Mae loss mitigation application that's used by most mortgage servicers. The Bureau decided that digitizing the loss mitigation application process had the potential to be helpful to consumers. And the second NOW template that can be used by insured depository institutions to apply for a NOW covering their small dollar credit products. So lots of relatively minor developments on the regulatory front so far this year, but of course we're expecting more significant developments to come later this year with the payday rule and hopefully some proposals around the small business data collection rule. Ori, I'll turn it back to you now.
Thanks. Just wanted to highlight a few additional developments over the past 6 months. First, in January, the Bureau issued a policy statement on abusiveness, setting forth, in the CFPB's words, quote, a framework for the Bureau's exercise of its supervisory and enforcement authority to address abusive acts or practices. Under the framework, the Bureau says it will do 3 things. First, it will generally rely on the abusiveness standard to address conduct only where the harm to consumers outweighs the benefits. Second, it will avoid making abusiveness claims where the claims rely on the same facts that the Bureau is also alleging are unfair or deceptive. And third, it will not seek certain types of monetary relief against a covered person who makes a good faith effort to comply with a reasonable interpretation of the abusiveness standard. And to just briefly address each of these points, so the first point essentially incorporates into the abusiveness standard a cost-benefit test that's not in the statutory definition of abusiveness, but is similar to one of the prongs of unfairness, which requires that any injury to consumers not be outweighed by countervailing benefits to consumers. The second point, which is that the CFPB generally won't plead abusiveness with respect to conduct that it also alleges is deceptive or unfair, might help to clarify over time what the contours of abusiveness are. Historically, virtually all of the abusiveness claims the Bureau have brought have also been accompanied by claims that the very same conduct that was alleged to be abusive was also unfair or deceptive, which did little to answer the question of what purpose the abusiveness prohibition served if that conduct was already proscribed by unfairness or deception. And the last point about not seeking monetary relief where an entity has made a good faith effort to comply with a reasonable interpretation of abusiveness, that appears intended to respond to claims that the CFPB engages in, quote, regulation through enforcement. And while it likely will be welcomed by regulated entities, it does raise the question of why the CFPB would seek monetary relief, in particular civil money penalties, in any case where an entity has made a good faith effort to comply with a reasonable interpretation of any law and not just abusiveness. Since the policy statement was issued, the CFPB has in fact brought two abusiveness claims. They were both in the sales practices complaint that the agency filed against Fifth Third Bank that I mentioned earlier. That complaint alleges that the bank's opening of unauthorized deposit accounts and on unauthorized credit cards constituted unfair acts or practices. And the complaint specifically alleges that opening those accounts without consumers' knowledge was likely to cause consumer harm, both in the form of fees that might be assessed and negative credit reporting. At the same time, the complaint alleged that the bank's unauthorized enrollment of consumers in online banking services and its unauthorized enrollment of consumers in certain lines of credit constituted abusive conduct. And those abusiveness claims did not plead any consumer harm. And indeed, that seems to be the reason that the Bureau alleged abusiveness with respect to those claims as opposed to calling that conduct unfair as well. That makes sense as a matter of statutory interpretation because, as I mentioned, abusiveness doesn't actually require a cost-benefit analysis. But it does call into question the policy statement's assertion that the Bureau will only plead abusiveness where the harm to consumers outweighs any benefits, which you would think would require them to articulate some harm. On the supervisory front, the Bureau issued another issue of supervisory highlights in February that summarized its findings of Bureau examinations conducted from April to August of last year. And it addresses findings in the areas of debt collection, mortgage servicing, payday lending, and student loan servicing. On debt collection, the Bureau noted it identified instances where debt collectors had failed to disclose that an initial communication to a consumer was a debt collector and failed to send required debt validation notices, both of which are violations of the FDCPA. On mortgage servicing, the Bureau identified instances in which mortgage servicers violated Regulation X by failing to timely send consumers who were seeking loan modifications notice that their applications were incomplete or notice of available loss mitigation options. In addition, in findings that have particular relevance now in light of the coronavirus pandemic, the Bureau also noted that servicers who provided consumers with short-term forbearance as a result of natural disasters improperly failed to follow up by providing borrowers with a required written notice setting forth the required information that was needed to have other loss mitigation options considered. But the Bureau went on to notice that because the violations were caused in part by servicers' efforts to handle an unexpected surge in applications due to natural disasters and occurred while servicers were making specific efforts to address borrower needs arising from the natural disasters, the examiners did not even issue any matters requiring attention for these violations. And that's consistent with the Bureau's subsequent statement on its supervisory and enforcement response to the pandemic, which Stephanie referenced earlier, and should provide some comfort to servicers struggling with overwhelming consumer demand for assistance, that the Bureau may be true to its word, as it appeared to have been in the supervisory highlights. The highlights also identified a series of issues with payday lenders, including failure to properly apply consumer payments, inaccurate disclosures of APRs, failure to retain evidence required by Regulation Z, inclusion of incorrect denial reasons and adverse action notices, and the imposition of unauthorized fees in connection with payment of delinquent debt. And finally, with respect to student loan servicers, the Bureau highlighted instances in which servicers included incorrect monthly payment amounts in monthly statements as a result of data errors introduced during transfers of loans between servicing systems. And then the last issue we wanted to address relates to a couple important personnel changes in the Bureau. Brian Johnson, who had come to the CFPB with Acting Director Mick Mulvaney back in the fall of 2017 and ultimately became the agency's Deputy Director, left the agency in March. And in a somewhat unusual move, Leonard Chanin, who's currently serving as the Deputy to FDIC Chair Helena McWilliams, is now also serving as the Acting Deputy Director of the CFPB. Press reports indicates that is on a part-time basis. Mr. Chanin was previously the head of Consumer Regulation Office at the Federal Reserve, and then was the first head of the CFPB's Office of Regulation in its first 2 years of existence, when all those regs transferred from other agencies to the CFPB's purview. And the Bureau also brought on board a new enforcement director this year for the first time in the agency's history. That is an individual who was brought in from outside the Bureau as opposed to from within the Office of Enforcement. Thomas Ward will serve as the new enforcement director. He comes to the CFPB from the Justice Department, where he has served as an assistant attorney general in the Civil Division. He was previously an associate at Sullivan and Cromwell. And for the first time now since Rich Cordray's departure from the agency in the fall of 2017, both the Office of Enforcement and the Division of Supervision, Enforcement, and Fair Lending that it's a part of will be led by individuals who've been hired by Kathy Kraninger and who are not at the Bureau at its inception. So the leadership of enforcement all the way up the chain now is no longer folks who were there from the beginning, and it'll be interesting to see if this results in a change in the Bureau's enforcement posture. And that is all we had for today. Thank you to our audience for tuning in. 3 brief reminders. You will receive an email with a link to the recording of today's call, and the recording will also be available as a podcast on your preferred podcast platform. For more information on Mayor Brown's extensive resources in relation to COVID-19, please visit our new website, covid19.mayorbrown.com. And lastly, as mentioned before, if you have any questions related to today's content, please email them to gfm@mayorbrown.com. Thank you again for your participation. You may all now disconnect.